All right, today's lecture is going to be a little bit of a throwback to your high school civics class. I want to make sure that we understand the overall context, how the government is set up, how the law feeds into that, how they play off each other. We're going to talk about some real world examples, and we're going to end the class talking about the Brown versus Board of Education case. So, as a review for you, going back to high school civics, somebody in the earlier class said it was elementary school. But either way, you remember that we have the system of government that we have. We've got a federal government. When I use the word federal, I'm referring to the government of the USA. Congress, the Supreme Court, the president. Those are the three branches of our federal government: legislative, Congress, executive, president, and judicial, Supreme Court. Okay. We also have those same separation of powers and structure of government at each state level. So the state of Georgia has an executive branch led by the governor, a judicial branch led by the Georgia Supreme Court, and a legislative branch, which is our Georgia legislature. Okay. Then you're going to find that replicated across all the other 49 states as well. So today's lecture is focusing on sources of law and sources of law within this framework of government that we have set up. If I use the broad term something legal or illegal, am I breaking the law or following the law? That could refer to a host of different sources of legal obligations, right? Laws would be a formal set of rules that society follows. We are governed. One of the reasons our country has been so successful is that we follow this idea of the rule of law. You've got a very short little article on the rule of law that you're assigned this week. The rule of law, in a nutshell, is that we all buy into, we all agree that we're going to follow the law. If there's a law that says we can't do something, we're not going to do it. If we disagree with the law, we're going to change it by making a new law or by taking it to court. Okay, we don't just take the law into our own hands. We don't decide what the law is ourselves. We're not governed by one person who can change the law on a day-to-day basis. If I get arrested and I don't think that I've done what they're arresting me for, I follow the rule of law and I challenge it in court, right? I go to court. I say I'm innocent. I get to have a trial. We all follow the same set of rules, and it gives our society, it gives our actions, our expectations, some certainty, some security, some stability. We all buy into and follow this system. This is being challenged currently. We're seeing a lot of tension between, at the federal level, the executive branch with President Trump making laws through executive orders, just basically things he's decreeing. All right, and that's being challenged right and left in the court system. And our courts are sorting out the limits of the power of the president to make law by executive order. It's not illegal for the president to make executive orders, but we do have a body of law that defines the limits, where that ends and where that begins. And the current administration, and I don't do politics at all. I'm bringing this up to you as an example of a real life application of the law in your lives and in our government today. This has nothing to do with political affiliation. The strategy by the executive branch this term is to do as much as they can by executive order, let it get challenged in court, and then have the court come back and set the limits. So they're pushing the envelope to see how much they can get away with every time. If the court lets them, then they've established a new level of executive power. If the court limits them, then it's cut back a little bit. Okay, there are going to be some Supreme Court decisions this semester on executive orders. There should be a decision during this term on tariffs. A lot of the tariffs were set through executive order, and they were challenged in court on the grounds that only Congress can do that. The president doesn't have the power to do that. So the Supreme Court is hashing that out right now. We should get a decision on that fairly soon. We should get a decision on the birthright citizenship that by executive order, the administration said we're going to end that being born in the United States no longer makes you automatically a citizen. That's being challenged in court, so we should get a decision on that as well. So all these things are not just, they're concrete. They're happening around us all the time. You might not realize it, and you might not realize the extent, but these are real everyday things that are happening now. So as you hear about these, I would encourage you to listen and see if you can try to figure out for yourself based on stuff we're learning and what you already know. Hopefully it'll give you a better understanding of kind of what's going on. If we get any really big, important decisions from the Supreme Court during this semester, we'll talk about them. We will definitely talk about them. So back to sources of law. Where all do we get laws from? I want you to be familiar with constitutional law as a source of law. We have a constitution at the federal level, the U.S. Constitution. Y'all are familiar with that, right? We the people. You had to memorize that at some point in school. The U.S. Constitution is the supreme law of the land. No law, any kind, anywhere else can conflict with that. It's the buck stops at the U.S. Constitution. Each state has their own constitution as well. So we got a federal constitution, and then we've got 50 state constitutions. The state constitutions are the highest law in that state. They cannot conflict with the U.S. Constitution. But as long as they're consistent with the U.S. Constitution, the state constitutions are the highest law of the land in that state. Our government was intended by the founders, our federal government was intended to be a really limited form of government. It has grown exponentially into something that is more than what they thought about. I'm talking about that in a minute when we get to administrative law. But the U.S. Constitution lays out the powers of the federal government. And if it's not laid out in the U.S. Constitution, then it's left to each state to decide. And it's set up to be pretty limited on what the federal laws can control, leaving it up to the states. So we've got constitutional law on a federal level and on a state level. We have statutory law. Statutes are passed by legislative bodies. So the president doesn't make statutes. The constitutions aren't statutes. Case law decisions by courts aren't statutes. Laws passed by legislative bodies are statutes. At the federal level, who's our legislative body? What we call them? Anybody? Who's our legislature on the federal level? Congress, right. At the state level, it would be each state legislature. Okay. There are examples in your outline of statutes. I'm not testing you on these particular statutes. I've put them in there as examples. You'll see that I put in there the definition of battery under Georgia criminal law. I've put in there the statute that makes it illegal to discriminate in employment on the basis of race, sex, national origin, religion, those type things. The reason I want you to look at those, be familiar with them, is that where constitutional law is pretty broad, not specific, right? Constitutional law will say things like, you have the right to freedom of speech. You have the right to bear arms. It doesn't get me much more specific than that. Statutes get a little more specific. But they still don't, they're not as specific, or they're not specific enough to cover every situation, every fact pattern. Here's an example. If you look at that anti-discrimination statute, you'll see that Congress passed the law, the statute saying you can't discriminate in employment on the basis of sex. See that word in the statute? The statute does not say what sex means. Does sex mean your gender? Does sex mean male or female? Does sex mean your identity? How does that apply to trans people? All right, that's not in the statute. So we rely on another source of law called case law. These are decisions by courts interpreting statutes. They're just as binding on us as constitutional law and statutes. Case law. Any case that's decided by a court results in a written opinion. Those written opinions are compiled into volumes. They used to be printed. I have them in the car. I forgot to bring them. I'll show them to you next week. Now we just search them all, obviously, on electronically. But when I was in law school, we had to actually go and find the volume that had the decision in it and read through it. Now you can do all your search terms and all that. Okay? But case law is this vast body of law interpreting statutes. It's binding on us the same way that any other laws are. We have an area or a source of law called administrative law. All right, administrative law is law that is made by executive agencies. So think at a federal level, the IRS is an executive agency. The Department of Homeland Security is an executive agency. The Department of Natural Resources is an executive agency. So it is up to these executive agencies to take statutes that Congress passes and implement them. And in doing so, they will often create rules that are legally binding that further flesh out and define and explain what is required under law. So an example of that in your outline is at a federal level, we have something called the Occupational Safety and Health Administration. Does anybody have to deal with OSHA rules in their jobs? You've seen the OSHA posters in the break room, right? Probably. What's your experience with OSHA? Okay. It had safety, probably a bunch of safety regulations. Yeah. 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 You have all these rules about your warehouse, right? About what you have to do. What's your experience been, Caleb?
I used to work in the warehouse, and they had like forklifts and stuff going around. So like, I mean, I never drove before, but I know they had lots.
Yeah. So for my people listening on the video, we're talking about warehouses, at shoe store, and other places, and forklifts and things like that. Congress doesn't have the time or really the expertise to sit down and write an occupational safety law that covers everything. Forklifts, ladders. I mean, Congress doesn't have the time to get into that. Plus, we have new inventions all the time. Things change. It's just that's not how Congress functions. So Congress will pass a statute that says our citizens have the right to be safe in the workplace, right? And we're going to task this administrative agency, OSHA, with administering the safety law and coming up with all these rules that everybody has to follow to implement the safety law. The examples that you have in your outline are rules about ladders, right? Congress didn't sit down and be like, all right, how much weight should each rung of a ladder bear? How many inches apart do the rungs on a ladder need to be? But I don't trust Congress to tell me what color the sky is, much less determine how much load each step on a ladder should bear. All right? But these are regulations and rules that are put out through administrative agencies. So if you think about the federal government from the time that our country was founded, when there really wasn't very much that the federal government did, to today, where it's hard to imagine any area of our lives that isn't affected or regulated by the federal government, from transportation to workplace safety to hiring and firing, you name it. So these rules, this administrative law, has grown and metastasized and really penetrated to a lot deeper level than I think the founding fathers anticipated. There have been some challenges to the limits of what an executive agency can do in terms of making rules. And the recent history is that the courts have been limiting executive agencies. They're trying to cut back on the authority that they're allowing them to have. They're trying to cut back on the number and volume and scope of rules that these administrative agencies are making. This is a current constant tension right now between the judicial branch and the executive branch who's overseeing all these agencies. We have agencies at state level too, right? Anybody in here hunt? You deer hunt? So you know when deer season is, right? Or if you got to look it up and make sure what the dates are. You know when you can use a gun and when you can use a bow. You know what days you can shoot does, which days you can't. The legislature of Georgia did not sit down and be like, all right, when should turkey season be? When should deer season be? How many bears should you be able to get every year? What they did was they passed a statute that says, we're going to regulate hunting. There shall be different seasons. There will be certain limits, but we're going to let the Department of Natural Resources, an executive agency, make the rules to carry out this law. We're just making a law that says there's going to be seasons, it's going to be regulated. We're going to let the agency come up with the actual regulations. All right, so that's something that Pierce County, how administrative law affects him personally. You might have thought coming in, administrative law doesn't affect me. Sure does. So we've got constitutional law, statutory law, administrative law, which are rules, and case law. It's important as we go through the semester, we'll learn to use these terms all correctly. And I do want you to know the difference and the distinctions between those. Case law can be confusing. So I'm going to do my best to explain how case law works. All right, case law is the result of court decisions. Courts will interpret a law, they'll apply the law to a certain set of facts, they'll write down their decision, their rationale, and then as they make those decisions become binding on future court cases. All right, so here's an example of how that works. You saw in the text of the statute, the anti-discrimination statute, the text said it's unlawful to discriminate in employment based on sex. Okay? We have had people challenge that law in court by saying, well, I got fired because of my sexual orientation. And I think that that's illegal under that statute, it says you can't discriminate based on sex. I think my orientation or that the word sex includes my orientation. Court, what do you say? The statute just says the word sex. So we need the court to say, does that mean orientation or does that mean just male or female? And the courts have taken those cases up. And the courts have said over time, up until about 2020, the courts said sex means male or female in employment discrimination. In 2020, the court changed their mind and said, we are going to now, from here on out, decide that the word sex in that statute does include orientation. Okay? So going forward, now that we have a court case, we have an opinion that's in case law that says that statute includes orientation. Going forward, that's the new law. That's the interpretation of the law that other courts in the future are bound to follow. Courts can and do go against precedent. They don't do it very often because as part of the rule of law, we all agree and buy into, the Supreme Court has the last word. If they say something's legal, then we're going to treat it as legal. But the Supreme Court does, at times, decline to follow precedent. They'll overturn precedent or they'll make new law. One of the best examples of that is going to be the Brown versus Board of Education case that we look at in a minute. Up until the Brown case, courts had read the 14th Amendment of the Constitution. The 14th Amendment says everybody's guaranteed equal protection under the law. That's all it says. It's constitutional law. No law can violate that. It's a pretty general statement. No one shall be denied equal protection of the law. These folks sued and said this law that says that our schools are segregated, I think that's unconstitutional. I think it violates the Constitution. And the court had to decide, does it? And I don't want to get too much into it because we're not quite there yet. But when you read that case, when you read the Brown case, the court takes you through their reasoning and rationale as to why there are all these previous cases that say separate but equal is fine. Not fine, but legal. If they just went by previous cases, they would have to find that the education segregation was also legal. But they found a way to distinguish the Brown case from prior cases, and they found a need to make new law. So as we read through that opinion, we get all their reasoning and we get to see why they changed the law. But unless a court has a really good reason for doing so, they will follow precedent. Now, I want you to understand sort of a basic operation of the court system. When a case enters the court system, that entry level is called a trial court. And this is not on the quiz for this week. This is getting into week 3 a little bit. But I think it's important for you to understand. The trial court is where we have the one judge in the black robe up front with the gavel, the jury, opening statements and closing statements, and lawyers putting on a show. That's where we have people on the witness stand being sworn in and being asked questions. That's where we're introducing evidence, be it photos, videos, pictures, drawings, writings, any kind of physical evidence that needs to be introduced. All that gets put out at the trial of the case before the trial court. The trial court determines what happened. What were the facts of the case? Okay? I get arrested for doing 90 miles an hour on University Avenue. I go to trial. The evidence is going to be the police officer testifying that he saw me speeding. That's some of his evidence. Some other of his evidence might be that he had his radar gun clocking me at 90 miles an hour. right? If I lose that case, anytime you lose a case, you have the right to appeal it to a next higher court. But what I want you to understand is when you appeal, you don't get a do-over on the facts of what happened. The trial court decided what happened. The trial court would decide Tebow was going 90 miles an hour, and he violated the speeding law. If I appeal, I don't get to appeal and say, well, they were just wrong. I really wasn't going 90 miles an hour. My appeal has to be that the law got applied wrong, that the law is unconstitutional, that there's some legal problem with it, not a factual problem with it. So as appeals go up, those courts are looking at legal issues. Was the law applied correctly? Is the law in question constitutional? And those appeals are where we get the decisions that constitute case law. The Supreme Court doesn't have to take every case that's appealed to it. It did take the Brown case. We'll talk about that in a minute. But that's where we get case law from. So if I'm an employment lawyer, all right, and somebody comes to me and says, I'd like to sue my employer, I think I got fired because of my sexuality. Well, I could go and I could pull up the statute and I could say, well, the statute does say that you're not supposed to be discriminated on the basis of sex, but it doesn't really say how sexuality fits into that. I can go and look up the case law, and there is a Supreme Court case that says sex does include not just gender, but orientation. So I can look at my client and say, yeah, we can sue your employer on this basis. We've got a statute that says it's illegal to discriminate on the basis of sex, and we've got this case law opinion that says that statute, that word in the statute does include orientation. We're good to go. Where we get all these nuances and where we get all these different interpretations is that let's say that there was a 2020 case that said that sex discrimination includes orientation, okay? Because the plaintiff, the parties in that, the guy was homosexual, he got fired, he claimed that's why. The case did not involve trans people. It only involved a homosexual person. So if I have a client that comes to my office who's trans and said, I got fired, and I think it's because I'm trans, do I have a case? I can say, well, we've got a statute that says you can't be discriminated on based on your sex. We've got case law that says that sexual orientation is included in that word. There aren't any cases yet on whether that includes trans. But I'll take your case and we'll sue your employer and we'll argue to the court that you've never decided this before, but you have decided cases similar to it. And what would be the difference, Judge, in trans than sexual orientation? There's no difference in your rationale. That would be my argument as the plaintiff's attorney. If I was representing the employer, my argument would be I would try to find a distinction between orientation and trans status that I could convince the judge that that case law precedent doesn't apply in the context of trans because I've convinced them it's somehow different. That's how the law keeps getting interpreted and keeps getting made. Let's talk about the Brown case then for a second. In the Brown case, hold on, before we do that, another basic point that I want y'all to understand, because we'll talk about this for the whole semester. There is a difference, or all law is broken up into criminal law and civil law. All right? All statutes are. So criminal law is that area that establishes conduct that is against what society expects and that you can be punished for, either by fine or by loss of liberty or even loss of life in extreme circumstances. Those are the criminal law. Murder, rape, speeding, embezzlement, breaking and entering, theft by taking. Those are all examples of crimes. We have volumes and volumes of criminal statutes. Those would be laws passed by our state legislature or by Congress at the federal level specifying what conduct is illegal. When we go into court at trial, it would be up to the government to prove that whatever the facts of the case were violate the definition of that crime. If they can't prove that the facts violated that definition, I might have done something wrong, but I didn't do that crime. Anything that's not criminal law is civil law. Civil law makes up the vast majority of the laws that we deal with. Hey, hopefully you never have to deal with any criminal laws. Civil law is divorces, contract disputes, employment discrimination disputes, suing your neighbor because their tree fell on your property, personal injury cases, car accidents. All that is civil law. Criminal law exists to keep order and to punish people for doing wrong and to hopefully deter people from doing wrong, right? That murder statute is there to punish people who murder, but also to keep me from murdering. Hopefully to keep me from murdering, because I know that if I do it, I'm going to have some serious consequences. Civil law is not to punish. Civil law is to compensate people for damages. They could be monetary damages, they could be emotional damages, they could be contractual. Maybe I agree to sell Ms. Rivera my house. We enter into a contract for the sale of real estate. I change my mind. I haven't committed a crime, but she can sue me under civil law for breach of contract, and she can have the court enforce the contract. Mr. Tebow, you are contractually obligated to sell her your house, so you're going to do it. What she wants is not me to be punished. She might want me to be punished, but her goal in suing me is to get me to follow the contract. That's civil law. What can get confusing is that sometimes the same act, same set of facts, the same action could result in criminal law consequences and civil law consequences. A great example of that is O.J. Simpson. Anybody not familiar with O.J. Simpson? All right. He played in the NFL, he was a football player, and he was a broadcaster. He was an actor, lived in Hollywood, divorced his wife. She had a new boyfriend, and he allegedly murdered them, killed them, took their lives. He was arrested and charged with the crime of murder. State of California arrested him, charged him with the crime of murder. So he was charged under California criminal law. He was eventually found not guilty by the jury in that case, if you've watched any of the recaps or if you've studied it. The families of his victims sued him in civil law, not for murder. They couldn't do that because that's a crime. Only the states have the ability to prosecute crimes. They sued him under civil law for something called wrongful death. Same set of facts, same set of evidence, but instead of them seeking, in the murder case, the state of California was seeking for him to be put in jail for murdering people. In the civil case, the families wanted to be compensated for the loss of their loved one's lives. Same set of facts, same evidence. Criminal case, they're trying to punish him. Civil case, we're trying to compensate the victims. In the civil case, O.J. was found liable for wrongful death. In the criminal case, he was found not guilty of murder. Does anyone know what explains the different outcomes? Same facts, same evidence. Now, these are two different trials. They were at different times, different juries. So that is one partial explanation. But does anybody know how we could get that result? It's because the burden of proof is different for criminal cases and civil cases. So in a criminal case, the jury or the judge has to find you guilty beyond what? Beyond a reasonable doubt. In a civil case, the jury or the judge is just deciding, are you liable? Are you responsible for the damages? And that standard is preponderance of the evidence. That means more likely than not. 51% to 49%, liable under civil law. 51% to 49%, that's not going to reach beyond a reasonable doubt in criminal law. Those are not the same thing. That's how we got two different outcomes in the OJ case. The jury in the criminal case did not feel that he had committed the crime beyond a reasonable doubt, while the jury in the civil case found that he was responsible, more likely than not. Probably so. A preponderance of the evidence. Ian and I could get in a fight after class. And we could be the only ones, let's say we're the only ones in here. We get into a fist fight, we both land some punches. The police could come, somebody could hear us, call the police, they could come. They could charge us with a crime if they feel like they have the facts for it. But they also might decline to. They might be like, look, we don't really see much damage. We can't determine who did what. It's your word against my word. There are no witnesses. We're not going to press charges. All right? But let's say that the next day I go to the hospital and I'm diagnosed with a concussion and maybe I got a tooth knocked out or something, and I want you to pay for that. I won't not pay by punishment. I want you to pay monetarily for that. I got hospital bills that I think you should be responsible for because you hit me. I could sue you under civil law, even though law enforcement is not pursuing any criminal charges. Same act, same event, same facts, same evidence. Civil law case and a criminal law case could result, or one or the other. Maybe the police arrest him or arrest me, but I'm not going to fool with suing him in civil court because maybe I just had some bruises. There's nothing I really have to get paid for. And I'm happy that they're punishing me. So I don't need to do a civil case. Okay, but that is something we're going to encounter for the rest of the semester. Everything we'll study is civil law. There'll be some criminal law, but I do want you to understand that there could be overlap in that the same set of facts could result in criminal liability or civil liability. That makes sense? I hope that makes sense. All right, let's look then at the Brown versus Board of Education case. So in just our basic legal lingo, the person who brings a lawsuit, the person who does the suing, is the plaintiff. The person who gets sued, or the person who a lawsuit is brought against, is the defendant. In a criminal case, the plaintiff is always going to be the government. If I violated a state criminal law, then it's going to be the state of Georgia plaintiff versus Tebow defendant. If I violate a federal criminal statute, it's going to be the United States of America plaintiff versus Tebow defendant. In civil cases, the name of the individual or the company or the entity that's doing the suing, plaintiff, person getting sued is the defendant. All right, so in Brown versus Board of Education, who's the plaintiff? Who's our plaintiff in this case? Who did the suing? Any guesses? Right, Bo. Who were they? They were parents, right? Parents of who? Of students who were, come on now, y'all didn't read. They were the parents of students who tried to get in where? A white school, and they were denied. That's the plaintiffs. That's Brown. Brown is one of the names. There were a bunch of different parents, but they've shortened it to Brown. The defendant in this case is who? The Board of Education, right? Is this a criminal case or a civil case? It's a civil case, right? It involves a state law. The state of Kansas said it's okay for these schools to be segregated. Or the state of Kansas, the Board of Education said black students got to go to this school, white students got to go to this school. The parents of these students sued, saying that that law is unconstitutional under the U.S. Constitution. What part of the U.S. Constitution did the plaintiffs say that law violated? What law are we talking about here? What part of the Constitution? Equal protection. That's found in the 14th Amendment. Equal protection clause of the 14th Amendment says that no citizen, or that every citizen shall be, or the laws cannot treat citizens unequally. It's a very unartful way for me to state the 14th Amendment. The laws will be applied equally to every citizen. That's what it says. Does it say anything about segregation in schools? No. So we probably got to go back and look for cases that have been brought challenging the 14th Amendment to see what courts have found in the past about what the 14th Amendment means. And it turns out that the Supreme Court had cases in the past based on the 14th Amendment in segregation. What was the name of the main case in Brown that the court had to deal with? What was the main precedent case in Brown? Sweat was one of them. There's another one. You're on it. You're not wrong. Plessy v. Ferguson was the precedent case. And Plessy v. Ferguson, did that involve education, schools? No, it involved what? Transportation. Okay? So we've got cases where there were state laws that said it was okay to have segregated transportation so long as the services provided by the government were equal. As long as everybody's being treated equally in terms of services, that is constitutional. That does not violate the 14th Amendment. Well, along come the Brown plaintiffs, and they say, this is unconstitutional, right? The courts would have to look at previous cases and say, okay, well, we've got this Plessy versus Ferguson case that says that separate but equal is okay. So how is this case different from that case? What reason are you going to give us for us to go against how we've ruled in the past? The plaintiffs in Brown said, yeah, we know you've ruled that way in the past, but those cases were based on public transportation. This is public education, and you've never ruled before on whether or not segregated education violates equal protection. We're asking you to look and decide that education should be treated differently than these other decisions that you've made. That's how the facts shook out. How the argument shook out. Now, remember I told you that at the trial court, the facts are established. So at the trial court, at the trial of this case, the plaintiffs would have had to come in and establish evidence that they enrolled their students in the white schools and that they were denied. So they might do that by, if they got a letter saying we deny you your admission, they might do it by calling in as witnesses the admissions people and saying, did you get an application from me? Yes. Did you approve it? No. Okay. That's where all the evidence and the facts were established. When we get to the appeal part, we're not arguing anymore about what happened factually. No one disputes that the black students applied to the white school and were denied. Nobody, we all agree that those are the facts. The appeal is based on the legal issue of whether or not that's constitutional. So we're not going back and retrying the facts of the case as we appeal it. Who won at the trial court level? The parents or the Board of Education? The first time it was tried with the first trial of the case, who won? Board of Education won. That's right, Ian. And part of the reason for that was that court said, well, we've got all these Supreme Court cases in the past that said separate but equal is constitutional, so we believe we're bound to follow precedent. The parents said, not so fast. We're going to appeal that. We're going to say not that the facts are any different, but we're going to say that the law was applied incorrectly. We think it should be overturned. So the next level of appeal, who won? Parents or Board of Education? Board of Education won that too. So then the parents were like, all right, we're going to appeal again. We're going to the U.S. Supreme Court, high as we can go. The Supreme Court, even though the parents have the right to appeal, the Supreme Court is not required to take every case that's appealed to it. The lower courts are, but the Supreme Court can't take every case. But they do tell you in this opinion why they took this case. Anybody catch that? They said, we're going to take this case because we believe that this is a matter of great national importance. This is a big deal. This is something that the Supreme Court ought to weigh in on. We need to decide this question once and for all. If the Supreme Court had not taken the case, then the decision from the lower court would have stood. Sometimes it doesn't make sense for the Supreme Court to take a case if it's just going to affirm what happened at the lower court. Sometimes they do. But this time they said, you know what? We've got these different, this is becoming where the lower courts are applying this differently. We need to settle this once and for all at the highest level there is. And going forward, what we decide will be the law. So the court starts out by saying, okay, this case is about the 14th Amendment. 14th Amendment was passed in what century? Like the 1800s. We're now in, what year are we in now in this case? 1950s, right? All right, so we've got this law that was written in 1800s, and we've got to decide what that means today. What was one of the main things about education, the difference in education between when the 14th Amendment was passed in 1800s and this case came to the court in 1950s? The court, in their opinion, is laying out their reasons. What'd they say about education? Yeah, it's one of the most important things, shapers of our citizens, right? Your education is a big determinant in your success. But when the 14th Amendment was passed in the 1800s, did the government educate students? Was there such thing as public education? No, it didn't exist. The government didn't do schools. They were private. Now, over all these years, we've got a system where not only does the government provide education, but it's arguably one of the most important things a government does. Education plays an outsized role in the success of students. So we're now looking at this law in that context. It's a context that the writers of the law in the 1800s couldn't even have contemplated because it didn't exist. So they say, going back and looking at what the founders, the authors of this law wrote isn't really helpful to us. Sometimes it's very helpful. This case is not helpful because our case involves something that didn't exist back then. So given the importance of public education, we're going to now read the 14th Amendment's guarantee of equal protection to include the right to equal education such that segregation cannot be part of it. What did the court say about the difference between the prior cases like Plessy that involved transportation? How did the court distinguish transportation from education? Now, I've already kind of said it. Transportation doesn't have the outsized impact on the development, the character, the morals, the opportunities that education does. Not to say that segregation in transportation is okay, but the transportation and education are not the same thing. Education is way more important. So that's one of the reasons that we're going to use as to why we're not going to follow the precedent. That had to do with transportation. This has to do with education. We are saying the separate but equal is not okay. Now, if Congress disagreed with the Supreme Court's decision in Brown, they could have gone and written the law a different way. They could have passed a new statute that says segregation is lawful. Okay, I know you said it isn't, but now you said it isn't in the context of public education. Now we're going to pass a statute that says that. It would get challenged again. The court would probably find that it's unconstitutional for the same reasons that it did in Brown. But I bring that point up to show you that just because the court, through case law, says that a law means this or is lawful or unlawful or constitutional or unconstitutional, that doesn't mean that Congress can't go back and try to write it a different way. That's the tension we have and the checks and balances we have. Congress makes the law, the courts say whether it's constitutional or not. You're seeing this play out in real time when it comes to abortion. So you're seeing the Supreme Court rule on, you're seeing these states pass laws that ban abortion after a certain period of time, 6 weeks, or the heartbeat rule, or these states are doing it differently. And then these laws are getting challenged in court, and some of them are getting struck down. And so you'll see states go back and rewrite their law to try to fit in under or to be compatible with what the case laws are saying, the cases are saying. I'm not saying this very artfully. But there's always a tension and not a game, but the way that our system of government works is if the people's representatives want to make a law, they can make a law. If somebody wants to challenge it to say it's unconstitutional, they can do that, and we'll have the court decide. So you see that playing out in real time right now. In a lot of the same way you see the executive branch pushing the limits of what laws can be made by executive order. So, any questions that y'all have on that? The question is, what is case law actually changing? Case law can interpret the statute, but case law can't change the words of the statute. So case law couldn't go in to the discrimination statute and say, we're taking out sex discrimination. Well, we don't like they can't edit the statute, but they can interpret it and expand on it. Does that make sense?
So you can build off of it, but you can't like take something.
You can build off of it. You could take something away You could take it like the Supreme Court decided in the Roe versus Wade decision that women had the right to have an abortion. And that was interpreting the Constitution as allowing that. When the Supreme Court in the Dobbs case a few years ago overturned Roe and decided that they were going to put limits on the woman's right to have an abortion, they did take away. So it does build on it, but it also could take away. It builds on it by taking, I mean, every time it's interpreted, it's further refined, either by adding to or taking away or defining one way or another. Does that make sense? Yeah. If these cases are interpreting this statute, that keeps going until the statute gets changed by Congress or until the courts decide they're going to read it a different way. But they're not rewriting the statutes. I mean, they are changing the law, right? After Brown versus Board of Education, no state is going to pass a law that says we're going to have segregated schools because the Supreme Court has ruled on that. If somebody asked a great question in the earlier class, which was, if the Supreme Court in Brown was only ruling on public education, why was that the last of any segregation in any area? Because the Supreme Court's ruling just was on segregation, it was on education. And the answer to that would be that any state government or federal government, they wouldn't pass a law making segregation in public schools legal because they know that the Supreme Court's ruled on that. But they might try to pass a law that's with a tweak in it, that's not exactly the same. Like maybe the city of Columbus decides that they're going to have separate garbage collection service for the races. They're going to be equal but separate. And I sue the city of Columbus and say, I think that's unconstitutional, right? The defense might say, well, it's been found to be unconstitutional in terms of transportation and public education, but you never really said it's unconstitutional in terms of providing garbage service. That might be the defense's argument. My argument would be, what is the difference? I mean, if it's illegal on something as important as public education, surely it's illegal on something as trivial as garbage collection. The rationale that the court used in that case pretty much shut down the idea that it could be, that separate but equal could be legal in any context. And so that was one where everybody just kind of understood after that, separate but equal will never fly. But there are a lot more less important laws and less technical laws that do get challenged because they're not as broad or they don't apply to other situations. That's why we constantly have cases challenging laws, because the facts might be a little bit different, or this law as it's written might be a little bit different than the one that you found was unconstitutional before. That's the game they're playing with the abortion laws right now. All right, any questions on that? All right, I think I'm cute by giving y'all Easter eggs, but then I realized that I don't remember where I hid them all. So I got to go back and find them, but I'm pretty sure there's one in Brown. I'm pretty sure there's one in your outline, and I'm pretty sure there's one in your rule of law article. All right, so Monday night, you will have a quiz on the lecture outline, the rule of law article, and anything that we've discussed in class. That's what it's over. It's open note. I'll post it later on this afternoon, and you can take it anytime you want between now and Monday night at midnight. Everybody got that? Tuesday, we're coming back in to start something new. And remember, next week is career prep week. Talked a lot about that. It has nothing to do with business law, but it is what it is. It is a really good, I mean, you need to come next week because you need to come, period. But you do need to hear what they have to say. I would not invite them to come speak to class if I thought it was something that was a waste of your time. So I think it's worth it. I learned a lot by hearing them talk about all the ways that employers are screening stuff now, and the hiring process is so much different than I had any idea. So I think it's important for y'all to hear that straight from them. So next week is only career prep. I will see y'all on Tuesday morning. And before you go, since I got 5 seconds, let me look at your names one more time. Did anybody come in after I took roll? Yes, sir. Don't tell me who you are. You are, I know who you are. You're Mr. Dim. All right. Ms. Bruner, Mr. Green, Griffin, Miss Hanson, Lindsay Hanson. Hunziker is back there. Miss Jackson, Mr. Jowers, Mr. Lockett, Miss Messeline, Miss Pearson, Miss Reed, Mr. Rivera, and Mr. Walston. All right, see y'all next week.